I was mentioning an assigned contempt matter for inclusion in the list. This was taken up by my lord on 18th of July and made returnable on the 22nd of August, my lord. The paucity of the court's time didn't permit it. My lord, may it appear, my lord, subject to my lord's convenience.
Inclusion. Anybody else wants inclusion? You can give. Yes. Yes. Let us see. Oh, that matter. What's wrong with this? Correction tomorrow to be mentioned.
This matter is relates to 2020 wrong questions, my lord. My lord, this matter
What do you want?
my lord, this matter was assigned to this bench, my lord. My lord, it was heard before the honorable Dr. my lord.
Just said all those who want inclusion, you give. For we are sorting out the matters for hearing. I have already asked the office to segregate the hearing matters. In a week or so, the hearing matters will fix a day for that. Don't worry. Then we'll see how your matter is placed. There's no point. Let us segregate the hearing matters. We'll fix a day for hearing, then we'll see. There may be others like you. Please look at it from our view. Let the matters be sorted out, then you mention. We have already directed. Yes.
My lord, may I permit to mention one urgent matter, my lord? This matter relates to recruitment of facility manager, my lord. The
Recruitment of
facility manager grade under the Directorate of Health Services, my lord. Now the recruiting body is proceeding with the recruitment process in contravention with the advertisement. This matter was taken up by the coordinate bench during the vacation bench, my lord, and the coordinate bench had directed the state to file a report, my lord.
no interim order was passed.
No, my lord, no interim order was passed, my lord. The only urgency is that, my lord, the recruiting body may any day conduct the CBT, making my OA infructuous. But this is the next stage of the selection process, that is a CBT, my lord. They may any day conduct the CBT that will make my way infructuous before the tribunal, my lord. Your lordship kindly takes you up this week.
When the test is announced, you mention. As soon as the test is announced, you mention. Yes, call the list.
As your lordship.
Leave to mention matter, lordship. This is my appeal. Lordship, this is an assigned matter, lordship. It has been assigned.
You want inclusion?
Lordship,
Give.
lordship, this is the fifth time I'm mentioning, lordship.
Why? What is wrong? It's not in the list. Inclusion you give. It will come in the next monthly list. Yes.
My lord, I am the petitioner in this matter, my lord. My lord, thrice the matter has been heard and passed in my favor. Judgment has been passed in my favor. Again, with the same reasons, respondents have made appeal and matter was to be listed after puja vacations, but they are not taking any steps for listing. And I am suffering serious hardship, my lord.
You are the respondent. You are the respondent.
Petitioner, my lord. The whole India is the respondent. 3 साल से 36th टाइम आ रहा हूँ मैं बनारस से my lord.
What is the last judgment in your favor?
Judgment in my favor.
You said
For appointment within 4 weeks. That was of May.
so. If already there is an order, why another case has been filed?
Yes, my lord. They have made appeal and this was the last order.
So let us see. What is the urgency? It will be taken up. Why? What is the urgency? It can be taken up.
My lord, 3 साल से unemployed
So
घर में
nothing is going to happen. Let us see. Wait for some time. Mention after a couple of weeks. No. Any date was fixed on that day.
after puja vacation it was to be listed and the
This
benches
MAT. Right now, which MAT is pending?
pending for hearing, my lord.
Oh, hearing matter.
Yes.
Then you wait after 1 or 2 weeks, you mentioned.
Item number 3.
Last question, my lord, your lordship. Heard the matter and my lord, state my lord, 6 accommodation. Take instruction, my lord. Question, my lord, page 42A, my lord. That my junior colleague has got promotion. That benefits would be given to me. 42A, my lord, that is. Here later. Page 42A, my lord. That is type copy. 42 is the original copy and 42A, my lord, type copy. Second paragraph, my lord, previously Sri Noskor has filed an application to inclusion his name in the respective gradation list. On the basis of the said application, his name has been included in the gradation list communicated such and such.
This is letter of 2013. Then what happened?
Then, my lord, file application before tribunal, my lord.
When?
Original application filed on 1st, my lord, 2017. Then, my lord,
What order was passed in that?
that was rejected, my lord, my prayer.
Where? Where is that order? What is the number, case number, OA number of 17?
Way number 1189 of 2017, my lord. During pendencies of this application, my lord, they passed reason order that is rejected my prayer. After that, my lord, I have filed, my lord, another OA 332 of 2019.
So where is the reasoned order?
Reasoned order, my lord, page 87.
87.
Yep.
87 is tribunal's order.
My-
We asked you,
Oh, my lord, that is tribunal. My reasoned order, my lord, in my opposition, in their opposition, my lord, page 18. Additional Secretary to the Government of West Bengal on 18/6/2018, it passed the order. Only a letter has been given. The undersigned is directed.
page 18.
Page 18 of the opposition, my lord. Opposition টা খুঁজে দিন।
So you did not annex this.
Page 55 of my application. Page 55. Object promotion to the post of AS grade 1. This is to inform him that he is not entitled to get the grade 1 PS promotion as per order such and such of the additional secretary of the government of West Bengal, land and land reforms and RR and R department. That is after that, my lord, that application, my lord, 2017 was, my lord, withdrawn and the original application dismissed as not placed. Then, my lord, OL 52 of 2019 was filed. Page 55 is their order, my lord. Only stated I am not entitled. Nothing has been.
Lordship. I beg your pardon, Your Lordship. Mr. Arjun Rai Mukherjee is appearing in this matter for the state. I have just been informed that he is not yet in court. I'm praying for a short Passover, Your Lordship.
And where is the order of 25/6/2001 under which you are claiming the benefit? And why have you not annexed the earlier withdrawal order from the tribunal?
Tribunal order in two matter, two order, my lord. First matter was business was withdrawn, that is annexed.
Where is that order?
At page 56,
Huh?
56. The first matter. Page 55, my lord, their order, reason order, and 56, my lord.
So you have not sought any liberty. Then how you can move afresh?
My lord, my prayer was to consider my representation. That was not considered. And in the pending, my lord, when the matter was running, suddenly, my lord, they passed this order. That is why, my lord, that matter was infructuous.
That's
After
not
that,
what we are asking you. We are asking you, when you have withdrawn without liberty, can you move afresh? We are not asking you suddenly and belatedly.
my lord, related, but that order cannot was not challenged in that petition, my lord. That order in page 55, that is my rejection, was not.
But your OA was for the same relief. Your OA was for promotion.
My lord, first really, my lord, first prayer was to consider my representation, and secondly, my lord, the order was challenged. My lord. Kindly consider this, my lord.
Which order was challenged in OA 1189 of 2017?
No order, my lord. In 2017, my lord, my representation was not considered. That is why my prayer was they should consider my representation.
Only for disposal of
My lord,
representation.
my lord.
Where is the prayer? Where have you said? It doesn't say anything. We don't know how you are saying this. Where is this matter stated in whose? In your OA have you stated this? In your writ have you stated this? Where have you stated this? And if you have not stated, then how you are making such a submission, sir?
In the last order, my lord, of the tribunal, my lord, there was no reflection. Kindly see, on consent of the learned counsel for the contesting parties, the case is taken up for consideration sitting singly, my lord. My lord, they were consented, but in the order, my lord, there is no reflection that earlier order, earlier matter was disposed without any.
So, then what are you submitting? Why you have suppressed the earlier prayer?
Suppression. Question.
Yes, we are asking you. What you say that you have made a prayer for disposal of representation. How you are making such a submission? What is the basis? Unless your client has stated either in the OA or in the writ, how you can make such a submission? Where is it? Show us. How can you make a submission of fact without anything in the pleading? And if it is in the pleading, then show us.
My lord, page 88, kindly see. Second paragraph last, the fact of having put up a representation before the respondent authorities in 2017, 4 years after his retirement, is also not in favor of this application. My lord, that means, my lord, my application was there, my lord, they were not.
That means that was the only prayer in your OA, and therefore you are making this submission of fact
No, my lord,
without any pleading. Wonderful submission.
in the order, my lord, that is kind.
Sir, you are a lawyer. You can't make this such kind of a submission. You cannot make up facts while you are arguing a matter. Either there is a pleading stated by your client or no. How you can make up such facts when you are making a submission? Making
My lord,
some.
kindly see page 7, my lord. Kindly go on to my page 7. Page 7 of my application.
Of
my application. Seven. Middle mileage J, point number G.
yes.
That as the respondent authorities considered and rejected the representation of the applicant, and as the applicant filed the said OA number 1189 of 2017 for non-consideration representation of the applicant by the respondent authorities, as such said OA number such and such became infractual.
So therefore, that is what we are asking you.
My lord, and learned advocate for the applicant on 6/12/2018 submitted before the honorable tribunal that OA such and such has becomes infractuous, and as such
Yes.
not willing to
Correct.
proceed further
Now
with
you
the
are showing us.
Yes, my lord, that was my lord stated in my
So therefore, we are asking you
My-
where you have stated. Yes. Now, where is that notification under which the promotion was being granted? 2001 notification, June 2001.
I rejected my prayer in 2000.
If we ask you something about apple, you will reply about oranges.
No, my lord.
We are asking you where is the notification of 2001, June 2001, under which the promotion you are claiming.
At page 41, my name was included in the
Where is the June 2001 order under which promotion you are claiming? Third time we are asking you.
This was 16. And then page 16. Page 68, my lord.
So this Bhumi Sahayak grade 1 post was created on 27/10/97.
Post was created.
Yes. No. Without saying anything first, no.
Let-
Please read paragraph 1 of the 25/6/2001 letter. LNLR Department Notification number 6858 GB3 dated 27/10/1997.
That was, they were given retrospective effect, my lord. That is why, my lord, after 96, I was not there. That is why my prayer, my lord, up to 1997, my lord, I am entitled, my lord. From 86 to 97, my lord, that was my prayer. In 1997, with the, through my lord face examination, I was promoted in the my prayer only up to 1997.
How can you get? You cannot get. You were not in the cadre on the day of issuance of 21/6/25. You had left the cadre.
My lord, but retrospective effect, my lord, they have given, my lord.
Show us where it says it must be given with retrospective effect.
My lord, district land and land reforms officer, my lord.
Don't show us any recommendation. Show us the policy which you are relying upon. If you have annexed it in the OA, we will see it. Otherwise, we will not see anything. Just because some officer has written a letter, the right will not be created in your favor. It will remain the right which is flowing from 97 creation of post or from this 25/6/2001.
My lord, but they allowed, my lord, my junior. That is my
He is still a Bhumi Sahayak.
no, my lord.
He continued as Bhumi Sahayak.
Grade 1, my lord, he got.
He continued, he did not become RI like you. The person you are claiming parity with, he did not become RI like you. He did not leave the cadre. He did not join a fresh appointment.
My lord, but before that, my lord, he was Bhumi Sahayak under me, my lord. He was
Before 97, 87, you were also Bhumi Sahayak. There is no problem. Hmm. And this benefit of 2001 notification, you have raised by a representation in 2017.
Sorry, my lord, I was before another division bench.
Yes, we were informed.
My lord, your lordship directed me to take instruction in this matter. My lord, I have taken instruction. May I hand over two paragraphs? although the notification dated 25th June 2001 is annexed to this writ petition, but it's bit illegible. My lord, I'm handing over the,
No, in your opposition, you have an extra clean
Yeah.
copy.
my lord, the আপনি আপনাকে দিয়ে দিন। My lord, the second page, it's the synopsis, my lord. May I just read, my The petitioner Balaram Noskar has submitted a writ petition before the Honorable High Court at Calcutta and stated that his junior colleague got promotion from Bhumi Sahayak to Bhumi Sahayak grade 1 with effect from 1st of July 1987, and he was deprived from such benefit. The petitioner was appointed as Tahsildar since 18 December 1975 and observed as Bhumi Sahayak with effect from 1st of July 1984. The petitioner got career advancement scheme benefit as per ROPA 1990 in the year 1994 after completion of 10 years of continuous service as Bhumi Sahayak. The petitioner left the cadre of Bhumi Sahayak and appeared in an examination for the post of revenue inspector in the year 1996, and being successful in the said examination, and he was appointed as revenue inspector since 9th December 1996 as fresh appointment, not promotion. The Director of Land Records and Service and
already
Land
there.
Reforms Commissioner West Bengal had selected Bhumi Sahayak designated employee.
Yes, so there is no change.
Whatever.
Whatever.
And my lord, your lordship kindly consider clause 7 of this 25th June.
Yes, we have seen that. You have seen that.
Therefore, my lord, once a person, my lord, gets the cash benefit, career advancement scheme, the precondition is, my lord, that he has not, my lord, got any promotion. That is the only condition, my lord, for getting career advancement.
So even if 2001 notification benefit he can claim, it can be only as per the terms contained therein.
Yes.
It's another thing that another stand you have taken is that he is not in that cadre anymore. He is appointed as revenue inspector. So either way, it cannot be given.
Yes.
That is what you have said earlier also. So there is no change. He is claiming parity with some other person.
My lord, once, my lord, the benefit under cash is extended to him, my lord, he is not entitled to get any promotion. Because cash benefit is given to those persons, my lord, who has
Obviously, who are stagnating. That's the whole
Yes,
concept.
that is the, my lord, object of the cash.
That is the whole concept of CS. Yes, nothing can be done. Yes, take down. Heard learned advocate.
Item number 4.
Yes. Per prayer.
Rejection was not challenged. The first order, first not challenged, second rejection not challenged, third rejection not challenged. Now we have fourth. First rejection and second rejection order has not been sound.
You have said in the way. And what about third rejection?
Third rejection, my lord. Third rejection, my lord.
It was served.
But my lord, is that I.
Third rejection. What is the date of third rejection?
I have. I have, my lord.
Page. Oh, that is tribunal's order. This was challenged. In which way? 34. Page 34, there is no order. Which page you are trying to? Hmm? 3. This is not 9th August. This is 9th February. You said August. You challenge this in which way?
Service on 10th. But has never been dealt with all the four rejection orders. And on this report, my lord, page 78. Very very it's 77.
Filed in time, they know the inquiry report.
It is very report, my lord, page 77. It is very report has been forwarded by the it comes from the other activity. Page 77. I am very report, my lord, page 70. But here the dependency has been
Dependency will come once application is within time. If application is not within time, then inquiry report means nothing.
application, my lord. I made an application, my lord, immediately after 4.5 years, 4.5 years after.
No, you did not.
After the date.
Please show after 4.5 years. That is factually incorrect submission, sir. So it's 5 years, 3 months.
After the notification of 2016, my lord.
Sir, one application your father made within 5 months of the death of your mother. Second application on without pro forma, you made it after 5 years, 3 months. Why you are saying 4 years?
2008.
Why you are saying 4 years? That is what we are asking.
4 months. 4.5 months. First application is
That we have already said. But the application on after you have when you have attained majority. No. In 2008.
2007, my result has been
Your date of birth is 80. How you can attain majority in 2007? That's why we are saying don't say wrong facts. That will not help you. Yes.
notification says that five years have been.
That's why you know everything. That's why we are asking you. So you completed 5 years on which date? In May 2008. When did you make the application? Huh? August. Only 3 months. So if 3 months, why not 3 years? The point is either it is within time or outside time. If 3 months can be condoned, then 3 years should also be condoned. We know what you are relying on. Up to 5 years. So therefore there is no scope. We have seen, therefore we are asking. What can be done? That inquiry report can be read to your benefit only if your basic application is in time. This the notification which came later in 2016.
2016, my lord.
That 16 clarification said 5 years, up to 5 years it can be accepted. It gave 2 illustrations that if there is no other person eligible, or if the person has died in action, both do not apply to you. Even if it was made applicable to you, it was only within 5 years. There's nothing can be done. Any way you look at it, you cannot get it.
Specified in this 54 of the notification without validity.
Yes.
In exceptional cases,
Two example are given. We have just said two example has been given.
in exceptional cases such as late during action, when none in the eligible except departments can consider request or compulsory appointment event when the date of death or retirement on medical grounds of a government servant is up to 5
Up to 5. Don't both these circumstances don't exist in your case.
While considering such related issues, the 3 member screening come inquiry committee should, however,
Oh, both these circumstances don't exist in your case. You have not applied up to 5 years. Then what can be done? Take down. Third learned advocate for the writ.
Item number 5.
For extension of High Court remedy.
For filing,
And on 10/6.
how much time?
It was ordered.
So we should proceed.
December.
You will get 1 week for reply. Within 2 weeks, he will file.
Item number 6.
I beg to appear on behalf of the petitioner. From the last occasion, your lordship was taken up this matter where your lordship form that your lordship the admissibility of the OBC certificate after closing date of the your lordship the notification. That was the moot question which was formed by your lordship. In support of your lordship the contention, my senior relied upon two apex court judgment your lordship, and to that extent your lordship the learned counsel appearing on behalf of the respondent asked your lordship to get instruction.
File.
Yes, Mr. Mukherjee.
October 2016 was considered record to the Lord Judge. The Lord Judge has not decided upon.
Rajnish Kumar Rai. Oh, Karan Singh Yadav.
Karan Singh Judge.
Karan Singh Yadav.
I think 24
No, see, this order was recorded by a different bench. Now his lordship will also have to consider. So therefore, we will fix a date in after 1 week. No piecemeal on that day. We will hear it out.
To that extent, your lordship, since your lordship the Karan Singh Jadhav, that was not decided by the lordship the honorable apex court.
So what it will be fixed for if you will make your argument today?
Yes, your lordship. To that, your lordship, since your lordship,
If you are making your argument today, then why we are fixing it for argument?
yes, your lordship. But the thing is that your lordship, the entire process of the your lordship, the recruitment is about to conclude. Since your lordship, the recruitment process your lordship initiated in 2019.
Yes.
See, it's your lordship, the half of the your lordship, the candidate that were already appointed for that post your lordship, which they are eligible.
List for consideration.
speeches. Item number 7.
Yes, call the next, not today. Next, not.
Item number 8.
Item number 8, my lord, I'm appearing for the petition. I'm praying for not today, my lord.
Why?
I'm led by Mr. Basu. He is not in the city today. He's had to.
Yes, not today, as prayed.
I'm grateful.
Item number 9.
9, my lord, similar prayer because Mr. Basu is not.
Yes.
Grateful.
Item number 10.
I beg to appear on behalf of the applicant. Petition. এটা কপিটা দে মানে last occasion my lords are pleased to direct us to file translate copy of the vernacular document. My lord, I have prepared a supplementary affidavit annexing the translate.
Supplementary affidavit is
Without fees. Fees দিবি না।
Item number 11.
In this matter, I appear for the state, Your Lordship. There was a direction of paper books have been
for filing
served, Your Lordship.
Lord, the learned advocate, Mr. Pradeep Kumar Tarofdar, senior advocate, is engaged in another court. My lord, I'm praying for a short passport.
Not today.
Item number 12.
Reply you want, we have filed.
My lord, reply, I think, my lord, it need not require. My lord, they have disclosed, my lord, the everything.
So after taking time twice for
I-
filing reply, you found out that reply has not to be filed. Anyway, whatever you want.
Will be ready to.
Yes.
And your lordship can come to my lord, the implement order. Yes, my lord, 37. Only the 2 points, my lord, they have time taken. One, my lord, I have constructed, my lord, dwelling house. That is, my lord, Pakka dwelling house. After the inquiry was made. And it is the one ground for rejection. And second point, my lord, I have suppressed the fact as regards, my lord, employment of my elder brother. He is, my lord, not government employee, he is semi-governmental. I said that he is employed in, my lord, school. School is not the government. So I have not, my lord, suppressed any fact. These are the 2 points. They have, my lord, taken, my lord, both in the interim order and my lord, legend order, and my lord, the order passed by the, my lord, tribunal. This is only one. And when your lordship kindly see the inquiry report. They have what inquiry report they have stated. 5 main inquiry report. Case my lord 20 affidavit in opposition. five-man committee is there, inquiry into this matter. What reveals from the inquiry report, your lordship will get it, my lord, from 20. My lord, page 22. Page 20 specifically stated that, my lord, what is the income of the family and what is the now, my lord, requirement to give appointment in favor of the, my lord, dependent, how much income is required to be taken into account. They said in the report, calculation was made in terms of the, my lord, circular. They said, my lord, yes, page 22. Page 22, you lost to get
Yes.
that is salary, 90% of the total salary, Sergeant Sir. Monthly income of the family after date of employee, Sergeant Sir. Death benefit, Sergeant Sir. And total income after this, my lord, Sergeant Sir, this so clearly it is less than the serial number 2. And hence the prayer of the applicant may be forwarded to the higher consideration for appointment of commission. It has not been disputed. Circular particularly said what income calculation has been made. How much calculation to be made, my lord, it is depicted from the circular. Circular said according to the circular calculation was made, family income. Family income less than, my lord, the income of the group C employee. And, my lord, it is, my lord, now so far, my lord, dwelling house is concerned. Nowadays, my lord, mud house with, my lord, roof, my lord, straw roof, it is not, my lord, available. Straw is not available. So when, my lord, after inquiry, if the house is, my lord, destroyed, then, my lord, there is no way just to, my lord, to construct a mud house. Mud house is totally abandoned. There is no, my
So
lord,
under a very,
straw.
very compelling circumstance, you had to construct a 2-story pakka house.
It is not. It is not like this. It is the building was there. Plot is not mine. It is my PWD plot.
That is not the point. We are not going to see what the structure is. The point is why is misrepresentation. That's the only
No,
point.
misrepresentation. You also kindly see that. See there, my affidavit. Misrepresentation. I have not done any misrepresentation.
Where is the application submitted by you? Where you have submitted that your brother is living separately and is semi-government.
Inquiry report stated.
Where is your submission on these facts? Don't try to show us the inquiry report. We are not going to rely on the inquiry report. You have submitted before the authorities that your brother is not staying with you. You are staying in a separate house. Your brother is semi-government. He is having such and such salary. Where is that?
I have been explained my affidavit that my father is self-employed. It is my lord, your lordship will get it from 15. It is their record. Affidavit. I have stated, clearly stated.
Please, we are ready.
My-
Applicant's name is Tushar.
And my lord, his father name is my lord.
No, this page 15 is not your application. Page 15 is not your application. Page
No, no,
15.
it is my lord application with affidavit. No objection. Application with affidavit, application is filed with my supportive of affidavit. In support of affidavit, no application to be proceeded. So there is no objection that my lord, this has been explained that my
Where is your application where you have stated that you are living separately?
I have not stated particular.
Why you are suppressing it from the court?
Well, it is my lord. I have stated the
Why you are suppressing it from the court? Why you are withholding that relevant fact from the court?
I am just make application only. Just my mother and my lordship will get it. Page my lord 30.
Again, we are asking you again. You have stated before the authorities when they asked you that you are living with your brother, you said, no, I am living separately and I have no house. I am having a kacha house. Where is that? And if you have not brought it on record, why you are suppressing it from the forum? Why?
My lord, my petitioner thought, my lord, the inquiry committee already made, my lord. Already, my lord, the inquiry was made. And my lord, here it is
Very well, then nothing can be done.
specified that my lord, my father is my lord self-employed. His income is not my lord.
Again and again you are submitting the same thing, and again we are saying the same thing. So we are repeating, you are also repeating, and we are also repeating. We are asking you to establish bona fide of your claim. We are not asking you what is your income. And you are shying away from that fact. You have not placed it before the tribunal, you have not placed it before us. In spite of our question, you don't want to place it, then it has to be inferred against you. There is nothing more that can be done.
The tribunal, my lord, your lordship, firstly, my lord, it was moved before the tribunal. Tribunal passed an earlier. Who order was passed? Hello. Lordship, kindly come to my lord, page 34. The order passed by the learned tribunal earlier. Matter is taken up. There of the applicant relates to setting a fact in the application completion of on the ground does not fulfill the act. Summation of the rate and the respondent by application completion of the result of was permitted. They submit the appearing view of the since the applicant did not fulfill the eligibility guidelines. And that's what made the order improved to order was citizen. And subsequently the order was passed to the you are appearing for the state.
Lordship, the earlier order, my learned friend is relying on, was rejected only on the ground of not providing a particular reason. Your Lordship, that reason and the reasoned order had been passed subsequently. Your Lordship will kindly see the affidavit. The sheer misrepresentation has been demonstrated, Your Lordship. Before the inquiry authority, it was demonstrated that the entire family income is only 24,000. Whereas in the post of a lower division clerk is ought to be 30,000 as on date of the consideration. But as a matter of fact, Your Lordship, on inquiry, it was found out that the entire family consisted of the mother, the brothers, including the elder brother, whose income has also been annexed in the affidavit, Your Lordship, at page 28. And the total income comes to around 80,000, gross income 80,000 per month, Your Lordship. Your Lordship, the regulations are clear that compassionate appointment has to be given only in cases of severe financial distress, Your Lordship, and immediate financial distress.
It does not say severe. It says 90%, less than 90%, or if less than group
Yes,
D.
Your Lordship. As on
That is all. The point is whether brothers or siblings' income can be clubbed with the
Your Lordship, it is
income.
together. They are staying together. And
So, therefore,
affidavit.
maybe we understand what you are doing, but where is the provision?
Your Lordship,
There is a pro forma prescribed for calculating the destitute, whether there is a financial crunch or not. In that pro forma, is there any provision for taking into consideration siblings' income? Otherwise, in the rule or regulation, is there any provision for taking into consideration the siblings' income?
Consist of, Your Lordship. All the family members.
No, we see there may be a government servant who leaves behind 5 children, 4 children and 1 wife. One of the child is on his own and he is earning and he has his own life.
Yes, Your Lordship.
Whether that can be clubbed to the
Considered, Your Lordship. But in this case.
So where is this provision? When you say that will not be considered.
your lordship, if the family is staying together.
No, we want to see where is this. When you say if he is living separately, it will not be considered. So where is the guideline? It cannot be an unbridled power in the authority. There must be something specified.
Here the eligibility indicates the family. Eligibility for the family is indigent and deserves immediate assistance for living from financial destitute. For any of the following monthly family falls within 90% euro.
Then two.
The monthly income is below the minimum salary of a cooking clerk or minimum salary of a lower division clerk.
Correct. There is no difficulty. But what is to be included while calculating this monthly income?
Members who are staying together, your lordship.
Where is that? Where is the guideline? What all is to be included for calculating the family income?
There has to be.
No, you will get it from the performer.
I shall get back with the performer.
Yes.
Because your lordship, in any event, I shall
13.
That is the point. That is there. We are staying with the person. Says the income which is based on pension and from the retirement to investment. I don't know how they can include club the things because we will have it how we after two brothers and I decide to live. He is not bound to the house, but it is happened. Not bound. Okay.
I appear in this matter for the petitioner, Lord. I appear for the petitioner. So this matter was taken up by your lordship on the last occasion. If your lordship kindly Lord, remembers the Lord, record, Lord, the case is relating to Lord, I understand. Correct. Now, Lord, the petitioner was given temporary promotion for 1 year in 2014. Now, Lord, from LDA, lower division assistant to estate supervisor.
State supervisor,
State supervisor.
estate supervisor,
Estate supervisor. That promotion was given temporarily.
for 1 year only.
For 1 year. Now, Lord, that was sought to be taken back in 2022.
Two. So
14
after 8
14
years,
14 was
after 8 years,
after 8
after 7 years.
7 years. Now, Lord, that was sought to be given effect and recovery was sought to be made. In fact, recovery was also made, Lord, to the tune of
The
rupees
promotion order was with a higher scale or higher
higher
pay.
scale. Higher scale. And Lord, in fact, Lord, the recovery was made, Lord, on monthly basis for about 70,000 rupees, 68 and odd. Now, Lord, that recovery has been made.
So excess payment is only 68,000 for 8 years, for 7 years.
No, because Lord, regular promotion was given after 1 year.
After 1 year.
After 1 year.
So issue is only of 1 year.
Only 1 year. Now, Lord, that promotion was, in fact, given retrospective effect. But that was sought to be taken back in 2022. Now, Lord, I shall just show your lordship 2-3.
No, in 22, what happened? The promotion was recalled.
Promotion was recalled from 2014. That was Lord, that was given effect from 2015.
So that 1 year was
1
recalled.
So, Lord, the entire thing
is only for 1 year.
Now, Lord, my humble.
Where is the recall order?
Yes, Lord.
Where is the recall order?
Lord, your lordship, kindly have a look to page 33 and 34. Lord, the serial number 5 is the petitioner. Kindly see last but one paragraph.
Yes.
Now, if your lordship kindly see page 31 for once. Page 31. This was the order of promotion given to the petitioner.
Temporary promotion.
Yes. Page 31. Kindly see, Orgo Mojumdar, lower division assistant, initially bearing pay scale number 6, unrevised, is temporarily promoted with effect from 1st September 2014 to the post of supervisor of estates on pay scale number 9, unrevised, white so and so. He is now enjoying pay scale number 6, converted into revised pay structure, pay band 2, so and so. After promotion, he is entitled to revised pay, and so and so. So his pay is fixed at rupees so and so with effect from so and so on the revised pay structure, so and so. ROPA rules 2009. Now, Lord, interestingly, Lord, your lordship has seen the impugned orders of recovery and Lord, dating back the promotion. Lord, then Lord, your lordship kindly consider another page which is very relevant. Lord, page 43 of the reply filed by the respondent number 3, page 43. Yes. Yes. Now, Lord, my respectful prayers before the learned tribunal were twofold. Recovery, even if affected, that should be refunded. That was number one. Number two, fixation, Lord, fixation of higher pay scale cannot be reduced. These are the twofold prayers I made before the tribunal. Now, Lord, I have lost. Therefore, Lord, this writ petition has come up before your lordship. Now, Lord, kindly see the Lord, I shall rely on a judgment of the Supreme Court. Lord, in this situation, what should happen? Whether I am entitled to the salary attached to the higher post or not, even if the promotion was temporarily given. The Supreme Court said, Lord,
With reference to which service rule?
Lord, this is no. This is Lord.
See,
That's correct, Lord. Rule.
Every service rule has provisions in this regard.
No,
when a person is made to discharge duties of a higher post,
right,
there are certain service rules where they say such a certain amount of additional pay has to be granted. Some rules say that the moment they assume the post, they will get all benefits attached. What is the provision here?
There is no.
It is governed by which
Lord,
service rule?
I have checked up West Bengal service rules. Lord, there is no such provision.
Mr. Mukherjee, in the West Bengal service rules, if a person is made to officiate on the higher post, what is his entitlement to pay and emoluments? Will he be made to continue to work on his lower post, or he will get anything? No, we are not asking you about confirmation. This is not a question of confirmation. Nothing in the rule.
Therefore, the principles of law laid down by the Supreme Court, but I'm placing reliance on this. But
Normal law is that the moment one assumes the post, higher post, he is entitled to all benefits attached to the higher post. Unless there is a rule otherwise.
But kindly have a look to paragraph 8. That is a proposition of law. Paragraph 8. 98, 5 SCC, 87. 98, 5 SCC, 87. Paragraph 8. 98, 5, volume 5 SCC, page 87. Paragraph 8, kindly see.
This is governed by West Bengal service rules. Service rules. West Bengal service rules. This brown one.
It is there.
There is a provision for officiation. Is there any provision for officiation? For officiation, is there any provision? So the pay scale of that estate, what is that pay? What is that post on which you are?
Estate supervisor.
So estate supervisor carries the same pay scale or it carries a higher pay scale?
Higher pay scale.
Yes, Mr. Mukherjee, both of you saying that there is no provision. Come to Rule 54. We are not on that.
Whether you want promotion money, but after the order of the finance department, only one post is available.
No, this post of estate, what is it? Estate supervisor. It carries a higher pay.
What post is provided, the post is available. Particular point of time, post is available.
So it was not available in 2014.
Okay, but can you page
Page? No, that will come later. We asked you what is the provision for officiating. You said there is no provision. There is a provision for officiating capacity. You also said there is no provision. Rule 54 is clear. You have not bothered to see. Last day also we had asked you. Unfortunately, you don't bother to go through it. You want us to look for everything. And if we rely on you, then we'll pass an order without considering the provision. What kind of assistance you are rendering? This is not expected from senior advocate.
which shall not have any substantive fee in respect of funds other than the tenured report, unless officiating appointment involves some responsible better.
Now read the next paragraph.
Because it was outside the ordinary line of
Outside the ordinary line also, yes. So whether in line of promotion or outside of line, if he is on a higher post, carrying a post of higher duties, then he will be entitled. Now, how it will be considered whether it is carrying a duties higher than the post, that is in the next paragraph. For the purpose of this rule.
Officiating appointment shall not involve assumption of duties or responsibility of better reported.
If the post which it is made is on the same scale. So therefore, this estate superintendent was carrying a post higher. It was not in the same scale. So it will be presumed that he was appointed to officiate on a assumption of the duties and responsibility greater than his post.
What is the post is available?
Where is this fact that post was not available? That comes later. First, we are asking you what is the law. There has to be a law. Both of you are saying there is no law. Page?
Page 67.
Yes. Where have you said in your reply filed before the tribunal that the post was not available? Twelve, 11.
Terms of the new post of legal assistant was created to be filled up by a function from the eligible candidates serving as UTA or equivalent post. In terms of the applicant order, the applicant post of totally file number two, opportunity 1:1 as per government policy adopted in 84. That is the terms of the applicant order. The total number of UTA or equivalent two residents. One incumbent serving or equivalent post was promoted in the post of assistant by two incumbents from promoted by your incumbent had to be stepped down. Here, not exercise the immediate object temporary basis and had to be stepped down from the previous post of which was considered to the government.
Yes, so you know, where is this fact that there was no post available?
So, then if there was no post available at the material point of time, then how could I be assigned the job of estate supervisor?
No.
I discharged.
There may be a mistake, but that mistake can only be inferred if there is an order subsequently that there was no post, still you have given this order. Where is this fact? Who has said that there is no post? In fact, they are supporting that he was rightfully he has discharged the duties. Respondent number 3 is supporting. Before the tribunal, you have filed?
No, the government has only the number 3 file.
They have not filed before the.
The government order was not challenged. Order of the official receiver was challenged.
Where is the order? Impugned order? But here they are supporting, you understand?
Okay.
31 of page 31 is the promotion order.
Page 33 and 34.
Thirty-three is issued by which authority? It is backward shifting of their promotion date. Why? It does not say why. Page 33. Page this is your reply filed before the tribunal. And where is the government order of 6/8 to 21? So which paragraph in your reply justifies the withdrawal of the benefit granted to him? In 84, there was a declaration that UDA, accountant, and this estate supervisor will all be in the same. So, where is that shifting? That's not at page 67 also. We don't find it. Where is that decision? That decision, the moment it says that the promotion date has to be shifted, it must be carrying the consequences also. Where is that decision? Two things. Where is the declaration or where is the statement in which communication that between 14 and 15 this post was not available? Because he has said post was not available. We are unable to find that. Secondly, if it has been shifted by an order, where does it say in the order that for this period, whatever has been paid to him, you have to realize it from him? Huh? This is of 22. This is an office note. This is not a decision. See, these are file notings, page 33, 34. These are not decisions. All of this is file noting.
One thing that may I point out, only one thing. From the reply filed by respondent number 3, paragraph 11 is the only relevant paragraph, according to me. Paragraph 11, I am just reading out. Now, at page subparagraph. Yes. Page 48, subparagraph 11.
Read it.
In terms of the aforesaid order, a new post of head assistant was created, which is to be filled up by promotion from the eligible candidate serving as UDA or in equivalent post. In terms of the aforesaid order, the aforesaid 3 posts supervisor of estate, accountant cum auditor, and account totaling 5 in number, stood apportioned in the ratio of 1:1 as per the government policy adopted in the year 1984. It is also stated that in terms of aforesaid order, since the total number of UDA or equivalent became 24, that is less than 26, one incumbent serving as UDA or in equivalent post was promoted in the post of head assistant, while the two incumbents from LDA post who were promoted as UDA or equivalent junior incumbent had to be stepped down to his previous post of LDA. Such exercise, your lordship, such exercise of the then official receiver was in implementation of the government order dated 6/8/2021.
That's what we are asking them.
So, 6/8/2021 is the government order.
That's why we said, where is the 21 order? Yes.
So that has been shown to your lordship, page 67.
Yes.
Now, Lord, I am putting a question to myself, Lord, whether 21 government's order can be applied in 2014, because that cannot have any retrospective.
67 is not the government order. No, this is 3/8/21.
3/8/21. Look, you wrote 8, at the left hand column, Lord, left 6/8/21. This is the government order. Whether this could be given retrospective effect. This order never had seen the color of the day in 2014. So whether that could be given retrospective effect.
It is not clear to me. Not clear to me.
No, nothing, everything is ambiguous. And Lord, money has been recovered from a poor Lord employee.
See, the post that you are originally holding has been considered as equivalent to accountant.
Yes.
And also this supervisor. Since 84, it is being considered equivalent.
May make the position clear, Lord. But I was appointed as LDA in 2009.
Yes. Then you became UDA.
Then I was entitled to be appointed as UDA.
Yes.
UDA is equivalent to estate supervisor.
Yes, and accountant.
Yes.
Both. All
Three
three are at par.
and other
Yes.
3. Now, Lord, my entitlement for being appointed as UDA, Lord, according to the respondents, arose in 2015, not in 2014. That's why.
Prior to that, you were not UDA.
I was given the duties to
No,
discharge.
prior to 15, you were not a UDA.
No, I was confirmed in LDA in 2012. In 2012, I was confirmed to LDA. Then, Lord, in 2014, since the post of estate supervisor was vacant and I was going to be given promotion to the post of UDA, I was chosen by the respondent to discharge the duties of estate supervisor for 1 year. Thereafter, regular promotion was given to me in 2015. This is the whole scenario. So whether the benefits which I was assigned and discharged, that could be taken away. This is the only question, Lord, for your lordship decision.
So what is the state government stand?
State government
regarding rule 54, why you are silent? If he has been made to officiate, how he can be deprived? Huh? Let us see the finance department's view with reference to rule 54, because rule 54 is clear.
I'm extremely sorry, my lord. I ought to have.
We asked you on the last day.
In fact,
Last day we asked.
I must be candid. I heavily relied on the juniors' findings.
Then don't say that there is. Then don't say there is none. You say I am not aware.
বন্দে বন্দে মাতরম 150 বছর
2 p.m.
Next to in
ইডেন গার্ডেন
Eden Gardens Park.
150 বছরের বন্দে মাতরম
Let us
Mute.
May I be permitted to mention contempt application, my lord?
This is the mentioning time. Oh, of this bench.
This bench. My lord, today is fixed for returnable date, my lord.
Tomorrow.
10.
11th or 10th. No, one case we were being shown in the chamber that perhaps 11th is fixed.
Group 7 assigned.
This bench or it is assigned to a bench which is presided by one of us. You see, most probably it is. No, you please check. Don't be on a presumption.
This bench, this is a review application where the state has preferred the review. My lord, we want an inclusion of the matter because we are not getting the benefits of your lordship thought. The review has been preferred by the state.
They have to file it. They have to move it. You cannot. Yes. Therefore, we are saying it is for the petitioner to. They will not. They may choose not. Yes.
I have a party to it, my lord.
You think we have not understood that? You think we have not understood what you are saying? You are saying because of review they are not implementing. Therefore, you are aggrieved. Still, it is their case. They have to move. You take steps for enforcing your order. That is in your hand, not this.
To mention one inclusion for review, Lordship, passed by your Lordship.
Next month.
Already mentioned, my lord.
Yes, we'll give the slip. We'll see.
Number one.
We find no infirmity in decision of the authority as well as the tribunal regarding disqualification of the petitioner's candidature for want of essential qualification. The writ petition is devoid of merit and the same is dismissed.
Item number 2.
But I appear for the respondent number 2 and 3. I appear for the respondent number 2 and 3.
I am for the petitioner, sir.
Right. Yes, the tribunal's order, it was considered opinion, does not warrant any interference. The writ petition is dismissed. Put it in envelope.
I don't know, 14 ছিল না? আরে 14
But I am for the petition. The reply. But here, the prayer of the writ petitioner was to
Appearing on behalf of the petitioner, my lord, there was a direction for filing affidavits. My lord, they have filed their affidavits. I have received it, and I require a 2 weeks time to.
Have they filed it?
But perhaps not, because they have served me within the vacation, just prior to the vacation, my lord. They served me, and I'm praying for 2 weeks time to file the affidavit in reply.
Not today.
Matter 16, 17 and 17.
Both sides are here.
One matter, state is not appearing.
The petitioner in the appeal which filed
One
by the
matter, he is
petitioner.
appearing for the petitioner, my lord. I appear for the respondent number 1, the private respondent, both the matters. My lord, and state has preferred one petition, another. Not the petition is there.
So in one case, state counsel is appearing, in another case, he is not appearing.
No, I am Purishad, my lord.
Okay.
Is that Ayurved Purishad matter, my lord? Long ago.
No, not long ago. We don't remember. I may remember.
Okay. And my lord, Justice.
So you will have to argue afresh. Otherwise, this bench has not heard you earlier.
Then my lord, another date will be fixed if you so.
No, what fixed? Let it come. Not today, since there is a resolution. Tomorrow we'll see what happens.
Yes. The order has already, one order is there, passed by your lordship. So far, their submission is concerned, they are supposed to, I have to make my submission, no, that was there in last one, but that as it.
Just make your briefly submission so that his lordship, he was not member of the bench. He will, then we can proceed.
Madam 18.
My lord, in this matter, I am for the petitioner, my lord. I am led by Mr. Vikas Ranjan Bhattacharya, my lord. Last occasions, kindly lordship remember, my lord. API score. The less.
Not today. Call the list one after the other.
Madam 19. 20.
Both sides. Both sides are present.
The last occasion, no one appeared on behalf of the respondent.
Today, whether both sides are appearing.
No.
No, then call the next, please.
21. 32. 23. 24. 25. 26.
And for the petitioner, my lord.
Next, call the next.
27.
I am for the also.
Call the next.
29. 30.
30, my lord, I am.
31. 32. 33. 34.
Petitioner.
35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 48 and 49.
I appeared in this matter for the petitioner, but I was just seeking an upgradation. Tomorrow, your lordship takes up slight upgradation.
Tomorrow, we'll see tomorrow. Not today.
50. 51. 52. 53. 54. 55. 56. 57.
57, my lord, matter relates to resignation of a doctor. Lord, your lordship has fixed some matters on 12th. Lord,
Let us pass the order tomorrow.
58. 59. 60. 61. 62. 63 and 64. 65. 66. 67. 68 to 70, 71, 72, 73, 74 and 75, 76 and 77, 78, 79, 80, 81, 82, 83, 84, 85 to 87, 88, 89, 90, 91, 92 to 94, 95, 96, 97, 98, 99, 100 to 105, 106, 107, 108, 109, 110, 111, 112, 113, 114 and 115, 116, 117, 18, 119, 120, 121, 122, 123, 124, 125.